We have Nima Rahmani, a former federal prosecutor, and Robert Tsai, a law professor at Boston University School of Law. Thank you, gentlemen, for joining me today. I want to first get your impressions of what has happened so far today with the vote. Now, this potential delay in the second impeachment trial of Donald Trump. More about that. Does this give the Democrats a little more time to pull some of those Republicans over to their side to convict the former president? What are your thoughts?
Well, possibly. I think that's right. That it's the first real surprise we've had in these proceedings, and the House managers really do need something to shake up the dynamic, which looks like it was headed towards an acquittal for the president. I think what's going to be really interesting about this is that already we have some insight into how at least some of the senators, we don't know quite how many that is, but at least some of the senators are willing to look at this question of incitement, this single charge, in the broader frame that the House managers have proposed, which is to not just see it as that one speech that the former president gave on January 6th, but rather as part of a broader plan to subvert the election and to use any means necessary to do so. Why do we have that clue now? Because of this evidence that is being sought, right? Evidence about a conversation that's taking place right as the siege is happening. And, if we ask ourselves, well, what relevance does this evidence have? These senators voted against the president's position, which is, let's take a narrower view of this, that this conversation, even if it happened, really has no bearing on that speech. So there's some people who I think are willing to look at this evidence and consider this as part of his state of mind. The House managers are arguing that this conversation and the way the president reacted is evidence of a guilty mind. That is consistent with him trying to capitalize on something that is awful that has happened, and perhaps even bears on his earlier plan, if he had one, to foment this violence.
Yeah, in fact, but Robert, I want to follow up on something you said a little bit earlier, because I'm re-listening to these arguments from Michael Vanderveen, and he's talking about this is just about the incitement. This is just about the speech part, where we know the impeachment manager spent a lot of time on what happened afterward, like you said earlier, to show intent and whatnot. But what did you think of him still maintaining that argument this morning, and how that may play out when they proceed with the discovery process and, of course, closing arguments, whenever that may come in the future?
Yeah, I think that although there's been a little bit of a crack exposed in the sense that, the defense has not been able to convince every senator on the Republican side that they should just focus only on the words uttered by the president on January 6th. We have to keep the sort of procedural rules in mind. And under the Senate resolution that's in place, there's going to be multiple votes before anybody ever gets to see a live witness. There's this preliminary vote that we just watched, which is whether the Senate wants to allow any subpoenas at all or any discovery. And as you might have noticed, there was a kind of a point of clarification sought, because what Congressman Raskin initially asked for was the right to subpoena Representative Herrera and to obtain whatever documents she might have that bears on this conversation with Representative McCarthy. And then he said, of course, he also wants to depose and talk to anybody else who might come forward. So there's a little bit of wiggle room, and there's a lack of kind of clarity as to what people were voting on in the first place. But what I suspect is going to happen, and what should happen, is that we will now see votes on specific requests for specific subpoenas as to certain people. So it sounds like at least as to Herrera. And then if the House managers want to go ahead and see what that turns up, and then seek a subpoena to depose McCarthy, or perhaps even former President Trump himself, then there should be separate votes on each subpoena in order to maintain clarity and prevent this sort of crazy situation where the lawyers are running around on both sides thinking they have authorization to depose anybody that they want to. So I think also that Vanderveen's, shaking of his saber, that if you go down this road, I want to depose 100 people. This is just sort of lawyerly bluster. He really doesn't want to do all that work, frankly. He just wants to prevent the Senate from going down this road. And once he gets realistic about that, I think what we'll see is they'll either make a handful of requests, or they won't make any requests at all and sort of see what gets turned up first.
Right, right. Makes total sense. Thank you, Robert. Thank you, Nima. We halt and we're waiting for some of these next steps. And I know, Robert, Tsai, you had some really good points from your expertise on how this could go moving forward. Revisit that for us on what you feel like maybe the rest of the day or how long this may even stretch out.
Absolutely. I think this is a huge win for the House managers. And, all along their theory of the case is that, as they've said to us, President Trump incited this mob. But the way we know that is because you have to look earlier than the January 16th moment, right? Their theory of the case is that the president summoned the mob, right? He assembled the mob, and then he incited the mob. And their theory is that explains why at that final last stage, he doesn't have to be more explicit. Everybody knows why they're there. They know why he wants them there. And at that point, he just has to point the mob up the hill. And everybody knows that what he wants is for them to obstruct the counting of the votes. I think that if they get this higher quality evidence as to President Trump's state of mind, kind of how he was acting and behaving, what he was saying to people, if in fact it's confirmed that he was on the phone trying to capitalize on this moment, it will show evidence of a corrupt mind, that he either planned or is trying to take advantage of this chaos to hang on to power. And that he's continuing to lean on people. So I think that, what we need to look for is, A, whether Representative Herrera repeats under oath in the deposition what she has said to reporters. And then at that point, we want to look and see whether Kevin McCarthy is deposed, whether they try to get him under oath, whether he confirms that story or what version he tells. And then, honestly, there could be some effort to try to, again, get Donald Trump to either come willingly or to get him a subpoena. And at that point, I would expect he would try to dodge that subpoena. But I think that there should be a lot of attention on this moment to try to see if people are willing to talk about what the president was thinking as all this chaos was unfolding.
Oh, yeah, it will be intriguing to watch it all unfold. You're right. So what do you guys think of this move? Robert, what do you think of Senator Graham's last-minute change of mind and trying to take to Twitter to clarify?
Right. I think that his last-minute switch got everybody's attention, but it would be a mistake to read into that move somehow that he has changed his mind and that he's open to convicting the president, or even that he wants to hear from anybody. It's purely, I think, a procedural tactic. Under Robert's Rules of Order, a motion for reconsideration can only be made by someone who voted in favor of the motion. And I think that's what's going on.
Bring in Robert Tsai. He's a professor of law at the Boston University School of Law. Robert, you have expertise in this. You've been enlightening us all morning long about what may be happening right now on the Senate floor. They took a recess. They returned. We see them in there just sort of discussing, milling around. We see some bipartisan groups huddled up talking to each other right now. Give us an idea of what they may be discussing.
Absolutely. The resolution that they're hoping to reach agreement as to will not just clarify how to proceed in this next phase, but I think what the senators will want to do is to sharply limit, fishing expeditions on both sides. I don't think that the senators really will have a taste for wanting, either side to go and, hunt down hundreds of witnesses. So I think that the bluster that you're hearing from the defense side of things, this is not going to come to pass. So if they can agree on 2 or 3 or 5, as many as 10, although I think that if the defense really wanted to depose 10 people, they would really have to make the case right now during this discussion period, to their supporters in the Senate that there's a good reason to do that many people. So I suspect that they're trying to get an agreement where you just have a handful of potential witnesses to be deposed on either side. This would allow them a few days to do it. My guess is they want a resolution that will allow them to come back at some point also next week, so that there would be a definite kind of cutoff point. And then, of course, to reiterate that there would have to be another vote, as the existing resolution provides for, before any particular live witnesses heard from on the Senate floor. So they don't want to have this proceeding careen out of control. And, quite to the contrary of what the defense lawyers is presenting, this is not like the typical civil trial where the lawyers have control of the process. The senators have a firm grip on what they want to have happen here. And, you might hear a little bit of howling on both sides, but we're not going to see, 300 people deposed. This is all fantasy.
Right. What about stipulations in this process, Robert? I see where Senator Kramer has suggested the idea for Herrera Butler to just give maybe a stipulated statement that would be a little more efficient to keep this process going, because it's moved pretty fast so far. This is definitely going to slow things down. But what about the possibility of that for some or all of the witnesses that are agreed upon?
Yeah, I don't think that's going to be satisfying, because if you're the House manager, if I'm putting myself in the shoes of, say, Congressman Jamie Raskin, who, by the way, has done a masterful job, I think, tactically, but also substantively, you want to be able to, in your deposition, get all the questions on the record, and her answers on the record as to what she heard McCarthy tell her about Trump and Trump's state of mind and so forth. And you want to be as complete as possible. If you give control to someone to just give you a statement, then you've lost that control. You've given it up, and they can tell you as little or as much as they want to. So you want that power to probe them under oath. And I think that also would not be satisfying to the defense side, because there's the potential here for information that will hurt their client's position. So they also want the opportunity, I think, to probe Congresswoman Herrera Butler. So I don't think you're going to see an agreement as to her. It's possible that if the House managers want to talk to other people, and there's a fight over this, because it's not in their interest to have anything drag out. If someone tries to resist the subpoena, then perhaps you end up in a place where a statement is useful. But I don't suspect that will happen with Herrera Butler.
Yeah, that's a good point. So I'm seeing right now on the Senate floor, intense talks underway about these next steps. Nothing has clearly been resolved just yet. We see some familiar faces, Senator Romney, Senator Kennedy down there talking to each other. How long do you think this process may last today? Do you think they'll reach some sort of consensus pretty soon? What are your projections at this point?
It's hard to say how long it will take them. I don't think that they're going to want to recess until they have got some sense of how to go forward. It's possible that they can't, and they get tired. That would leave us in a situation where, without that resolution, you're in a world in which, in theory, each side could just ask for a subpoena, and then you'd have the situation where the Senate would be forced to take a vote individually. And I think there'd be discomfort in doing it that way. There'll be certain senators who won't want their names associated with those particular subpoenas because of the political ramifications that they perceive. So I suspect they'll try as hard as they can to try to hammer something out where we have a very defined number of people that can be deposed, and then they'll recess and let that happen.
Well, we are watching on standby. I have so many more questions for you, Robert, but we're going to take a break right now. Before we come back, we're going to keep our eye on the Senate floor for any developments on the record. But for now, we're going to take it to break. This is Court TV Live, your front row seat to justice.